Thank you. Captioning. Maybe, I needed to. You did the caption, yeah. There we go. I don't hear your voice went away. It's good to do a lot of vlogs in advance. All rise. May be seated. Thank you. Good morning, everyone. I want to welcome you to the Kansas Court of Appeals here in Topeka. My name is Henry Green, and I will be the presiding judge. And the other judges are here with me is Catherine Gardner and Judge Stephen Hill. Okay. Before we get started, this case has been set for 15 minutes, but I've gotten with my other judges, and we decided to let you have 20 minutes, okay, for argument, okay? And yes, I guess it's a time where I can call the case. It's 11 o'clock. The This case that we have this morning is the number is 126699. Jennifer Harding and Samantha Ramirez, individually and on behalf of all others similarly situated appellants versus Capital Federal Savings Bank appellee. And I need to get the appearances. Appearing for appellant.
Your Honor, David Seeley on behalf of the plaintiffs and appellants.
And Mr. Seeley, would you want some rebuttal time?
Yes, I'd like to reserve 5 minutes if I may, Your Honor.
5 minutes. And appearing for the appellee, Capital Federal Savings Bank.
Good morning, Kirsten Holsteter for Capital Federal Savings Bank.
Okay. Now, Mr. Seeley, are you ready to begin your argument?
I am, Your Honor.
Okay, are we ready to hear it?
Thank you.
All right.
May it please the court. My name is David Seeley, and it is my privilege to represent the plaintiffs and appellants in this matter, Jennifer Harding and Samantha Ramirez. These two women, like so many other Capital Federal customers, are victims of the systematic, routine, deliberate deduction from their bank accounts of Capital Federal's established overdraft fees on debit card transactions that were actually authorized by Capital Federal, and by the regular intentional deduction of multiple NSF or insufficient funds fees for a single attempted payment transaction that results in an overdraft. And we are here today because the district court at the hearing on Cap Fed's motion to dismiss under KSA 60-212B6 erroneously viewed the plaintiff's amended petition and the defendant's motion to dismiss through the wrong lens or lenses, which led it to wrongly dismiss the plaintiff's claims with prejudice. And the court did so in at least two respects. First, by disregarding the established standard that a court must read the factual allegations in the petition in the light most favorable to the plaintiff, and with every doubt resolved in the plaintiff's favor, and must assume as true those facts and any inferences reasonably drawn from them. And second, by piercing the pleadings during the hearing and basing its decision on matters outside the pleadings. It is important to note that the district court expressly based its dismissal solely, quote, solely on the contractual notice provision, unquote, of the Capital Federal Customer Account Agreement. That notice provision states that a customer must give CapFed written notice of, quote, any errors or improper charges, unquote, such as fraud or forged signature, within 30 days from the date the monthly bank statement was mailed, or the customer's claim is forever barred. The underlying issue here is whether the phrase improper charges objectively and reasonably refers to fees that are regular, established, and deliberately imposed pursuant to CapFed's standard systematic practices and policies.
Counsel, did the lower court ask for briefing on that particular point, or did the court just entertain argument and resolve it as a result of a motion?
It did not request any specific briefing, Your Honor. Those were issues that arose within the party's briefing and in the hearing itself.
In its resolution of that issue, is it your argument that the court engaged in fact-finding?
Yes, Your Honor.
How so?
Specifically, Your Honor, the court went past the general averment that all prerequisites to the bringing of this action had been satisfied, which is a general averment is recognized as valid under Rule 209 and under the case law of this court and the Supreme Court. And the court pressed my co-counsel, Mr. Jeffrey Khalil, to explain whether he had any knowledge of any efforts on behalf of the plaintiffs to notify Capital Federal. And in doing that, first of all, to say that Mr. Khalil was surprised would be an understatement. One does not ordinarily in a hearing on a motion to dismiss expect to be asked questions about facts that are outside the pleadings. But Mr. Khalil candidly told the court that he was not aware of any, having not been the person who interviewed the plaintiffs regarding the facts of their claims initially.
Didn't he go further, though, and say, if the court finds the notice provision applies here, quote, we did not alert the bank within 30 days. Yes, that is correct.
He did say that, Your Honor. But again, that involved a matter that was outside the pleadings. And I would respectfully suggest a matter that Mr. Khalil was not fully informed regarding and was not prepared to give an exhaustive and authoritative answer.
Is it binding upon his client, though, that admission?
I believe not, Your Honor. I think once the court transgressed and pierced the pleadings, raising that factual issue and then wading into it in an attempt to resolve it, that the court could not rely on an admission or any statement, assuming that it rises to the level of admission, regarding that matter.
In the old days, we used to call these demurs. And you didn't do anything that wasn't in the pleadings. And that's basically your argument today. Because this notice provision was not involved in the pleading, it was immaterial to what was before the court. Is that what you're saying?
Well, it's actually more complex or perhaps nuanced.
Educate me then.
Because this notice provision wouldn't have made any difference anyway. Because the claims in this case are based not on an unusual or atypical event, but from the routine
It's a
systematic.
routine charge that you're complaining about.
That's correct. And because of that, there's no reasonable inference to be drawn that, and which again would be contrary to the rule requiring inferences be drawn in favor of the plaintiffs here.
So it's your argument then that the court found as a matter of law, Section G or whatever it was applied with no facts, with no evidence.
That's correct, Your Honor. That's
The
correct.
binding portion of it was Section G and therefore notice was required. That's essentially what the court ruled, correct?
That is what the court ruled, Your Honor.
And what facts did the court rely upon? The admission of counsel?
That's what I understand, Your Honor. But in doing that, the court engaged in I would say a circuitous route to get there, because instead of looking at the notice provision and determining whether it was susceptible of more than one reasonable interpretation, the court latched onto the idea that the agreement had to be read, quote, from the perspective of the account holder, unquote. And where that standard came from, I do not know. I can't find it in any Kansas case. I can't find it in any case anywhere else.
Did the court cite any authority?
No, it did not, Your Honor. But in doing that, the court, that effectively knocked the court off track. It skewed its analysis. Instead of entertaining the idea that this provision might be susceptible of more than one reasonable interpretation, it concluded, as a matter of law, it appears, that it could be read only as from the perspective of what the court deemed to be the perspective of the account holder. And so construing the term improper charges then under the court's view from the perspective of the customer, the bank's customer, means anything wrong. It's all encompassing.
If we were to affirm, is it your argument then that we would also be compounding the error because we would be basing it upon a factual finding?
Yes, Your Honor.
And a conclusion that subsection G of the contract applies.
Yes, Your Honor.
All right, thank you.
I believe those are actually issues that depend upon findings of fact. What happened? What evidence is there, if any, that it would have made any difference if Capital Federal had received some form of notice? I think the reasonable inference that should be drawn in favor of the plaintiffs is that it wouldn't make any difference because it involved not an odd event, unexpected event, but a systematic routine practice by the Capital Federal.
The important question now I have for you, if we were to reverse this and send it back, that's fine. But what directions would you ask us to give the district court if we were to reverse?
Well, I think, Your Honor, because the court's review here is de novo, the court can effectively address the merits of the motion to dismiss in the present posture. And having done that, the court can send the case back to the district court for further proceedings, including discovery, motions for summary judgment, et cetera. The other technical problem that we have with the court's invasion of the factual terroir, so to speak, is that the court effectively converted the motion to dismiss under 12b-6 into a motion for summary judgment under Rule 56. And in doing that, if the court had given us notice in advance that this is what we're going to do, I want the parties to address this issue of whether notice was given, present me with affidavits or other evidentiary materials in support of that motion, and then let's have a hearing.
All
But
of
in
this is done prior to, because no answer has been filed.
Correct.
This is a motion to dismiss the
That's right.
demurrer.
Right.
All right, thank you.
Let me ask a couple
Sure.
procedural questions. I think you answered one, and that is the parties did brief and argue below that this particular phrase was ambiguous.
Yes, Your Honor.
Okay. What about unconscionability, which you're arguing on appeal?
Yes, we also argued that, Your Honor.
Okay.
And the argument's very simple. This was a take it or leave it agreement. There was no invitation there's no indication on the face of it that there's any indication for negotiation. The inference to be drawn is there is no opportunity for negotiation. And this is an agreement that is on its face one-sided and unfair. And we believe that satisfies the standards for unconscionability under Kansas law. But the district court really didn't grapple with that. And we think that is something that perhaps this court could address on appeal. Again,
You
it is
think
to
you
know.
actually preserved that issue for us, unconscionability?
Yes, Your Honor.
You do? Oh, okay.
I believe we did preserve it.
All right. I just didn't see a real strong argument that as far as.
I believe in the transcript unconscionability was mentioned.
Okay.
It's certainly mentioned in the briefing on the motion to dismiss as well. And in fact, it's also included in the petition itself. So I believe that's sufficient to preserve the issue for review by this court.
And let me ask you a question. When I was reading your briefs, okay, and I think initially on page 11, in the first paragraph, you said, further, if this language employed in crafting the notice provision was ambiguous or unclear, the court was required to strictly construe the provision against CapFed as a drafter. You say against CapFed.
Yes,
But
Your
in your reply brief, and it was somewhat confusing to me when I was reading your reply brief, if I can find the page. On page 2 of your reply brief, and we're dealing with the first paragraph, and it's the last sentence. And you said, and because ambiguities must be construed against the bank, then you have this phrase, as the non-drafting party.
Oh, it should be the drafting party, Your Honor. I apologize.
So that's the typo then, huh?
Yes, it is, Your Honor.
Okay.
Yes.
Okay.
I apologize for the confusion.
Okay. Well, you clear that up. Also, on that same page, you make this argument. You're saying that CapFed is guilty of the same attempt to have it both ways. Can you explain how you believe?
I'm struggling to remember the reference exactly, but I think that refers to the fact that Capital Federal was saying that we were trying to use improper purpose.
As far as the improper,
Improper.
that covers
Yeah.
not only,
Right.
like fraud and stuff of this nature, but and it covers fees too.
Correct.
Okay. And the trial court, I think the trial court actually made a determination or said that improper charges wasn't ambiguous, right?
Correct, Your Honor. But we have cited cases in our brief where courts have specifically held that improper charges are ambiguous in vague terms. And we believe that the court, again, latched on to the notice issue or whether notice was given and kind of leaped to the conclusion that it applied and then had tied its own hands in terms of its ability to consider such issues, such as whether agreement was ambiguous or unclear in any way.
Okay, you have 2 minutes before you get into your rebuttal.
All right, thank
I
you.
do have another question. When we think about ambiguity, we usually say that this phrase or sentence has two possible reasonable meanings. What are the two possible reasonable or more meanings here for improper charges?
Well, I think that the way I have always approached this is that the term improper charges is silent as to whether it refers to routine fees established and systematically enforced by Capital Federal. And so the question is, what is the breadth of that term? Does it encompass anything that could conceivably happen? Or should it be viewed in the context of this notice provision, which speaks specifically in terms of fraud, forged endorsement, errors, things that a bank would have reason to want notice about so they could investigate because it involved the conduct of a third party or some aberrant event that happened out of the blue. But here we're talking about a completely different scenario where it's the bank's routine application of its own fees that it knows well that it is doing because that's the way it is set up to operate. And there's no need for any investigation, and therefore there's no need for any notice.
Your argument was below was pretty much there's no duty to give notice within 30
Correct.
days because it would have been futile
Correct, Your Honor.
because it's one of their routine fees.
That's correct.
So charges from a third party as opposed to perhaps charges by the bank.
Right. Again, it's that context that is critical. What does the bank have a true need for notice about? And what does it have that it doesn't, and what does it not have a need for, but wants to use it as effectively a statute of limitations to cut off any claim that's not asserted within the first 30 days? And that's to me, the real injustice that is here. And I think the district court at some level struggled with that because it said, if it weren't for this notice provision, I would have denied the motion to dismiss and let the case proceed. I think we just have to walk back a step, say the district court got off track, put him on track again. The petition states a claim upon which relief can be granted, and then allow the case to proceed in the ordinary course. Thank you.
Thank you. Eppley?
May it please the court. My esteemed colleague has spent most of his argument talking about what was outside of the pleadings in this case. And Eppley admits that the scope of the pleadings is important for a 12B6 motion to dismiss. So let's look at the pleadings. The plaintiffs cite in paragraph 110 of their amended complaint or amended petition, excuse me. They make a conclusory allegation that they complied with obligations under the agreement. But they didn't stop there. They didn't rely on just that conclusion. Instead, they chose to plead the notice provision and their position on the notice position in the first amended petition. This is part of the pleadings. And this is how plaintiffs characterized the fees that they're disputing in this case. In paragraph 78, I'm quoting, "The improper fees charged by defendant to plaintiff's account were not errors by defendant, but rather were intentional charges made by defendant as part of its standard processing of transactions." End quote. So that's their position here today, that an intentional fee is not an error, but they also call that an improper fee.
Counsel, let me ask you a question about this. Is it your position in this hearing today that subsection G of the agreement controls this?
That the notice,
Yes, this notice provision, because they didn't comply with it, the court quite correctly dismissed.
yes,
All right, and that's your position today. So you're arguing that subsection G controls this, that they were required to give you within 30 days that notice and they didn't do it.
correct.
And why isn't that a factual finding? Didn't the court find facts then?
Well,
And this is a motion to dismiss. the old-fashioned demur, all the factual, all of the implications, all of the nuances go towards the person that's making the claim. Why isn't that a factual finding?
It is not a factual finding because of allegations that the plaintiff chose to make in this case. Had they relied,
Wait. Because they use the term improper, they're saying, they've already characterized it as improper. We got you. You didn't do the 30 days. Is that it? Is that your argument?
Your Honor, on the motion to dismiss, the defendant put directly at issue paragraph 78 to 80 of the first amended petition, where the plaintiffs say they had no duty to report as errors because they believed it did not apply to intentional fees. They said they had no duty. At oral argument, plaintiff's counsel said that was a legal position that they asserted in this first amended petition.
Well, is it your position today that they had to comply with subsection G?
It is my position that plaintiffs have to comply with provisions of the agreement, which included the notice
And the
provision.
court agreed with you, because that was
Correct.
your argument below. And the court concluded they did not do so. And that was relied upon something pulled from some attorney's admission. So why isn't that a factual finding that you're not supposed to be doing?
Because on a 12b6 motion, the court is required to look at the allegations of the petition. So a party cannot make an inconsistent position in a pleading and then say, well, the court, you need to disregard that. They chose to say that they did not comply with the notice provision.
They certainly made a lot of argument at that hearing that I've read that these fees that you're talking about here, this APPSN fee and the NSF fee were routine charges that your bank makes routinely. And they obviously maintained that argument that doesn't apply to routine charges, and then we're talking about routine charges. So it seems like to me that the court made a factual finding, says, hey, you didn't comply with the time, you're out.
So in the motion to dismiss, Cap Fed argued that 78 to 80 were a concession by the plaintiffs in the scope of the pleadings, that they were relying on the legal argument that these fees, which they labeled as improper in the petition, did not fall under the notice provision. In the motion to dismiss, Cap Fed expressly said plaintiffs have conceded non-compliance.
Along that same line then, let's follow up your logic. You're also saying that the court resolved ambiguity in your favor, and you're not the one that, according to the standard of review, all ambiguities are to be resolved in their favor, correct?
There is only a inference against the drafter if the court first finds as a matter of law that there is ambiguity. And if you look at the briefing on this appeal, the plaintiffs opened by saying improper should be read under this definition of Black's Law Dictionary. And then if you look at the same Black's Law Dictionary, there's another definition where improper is defined as anything wrongful, whether intentional or unintentional.
It's the sorry duty of courts many times to resolve ambiguous terms. And we do it all the time based upon the contract. Ambiguities should be resolved by the terms of the contract that the parties have here, isn't it? Not by some argument made by counsel.
So
I didn't see any of that in the court's ruling.
the court ruled that the phrase was unambiguous. And if you look at the pleading, the fact that plaintiffs routinely label the fees that they're disputing as improper shows that there is a common understanding of that term, and it is not
Common understanding by whom?
by the plaintiffs who were alleging, in order to assert a cause of action, they argued that these fees are improper. Improper. They
Argued
disagreed.
that they were illegal. And they also argued that other things as well. So the court picked one part of their and bound them to that. And well, I'm having a difficulty getting around to your fact finding. But go ahead, finish your argument.
So the motion to dismiss expressly put this point at issue. It said, paragraph 78 and 80, plaintiffs, you volunteered the opportunity to take on this notice provision, and you chose to address a portion of it. You chose only to address the word errors and not improper charges. So in the motion to dismiss, CapFed puts at issue this concession that they believe they had no duty to comply with the notice provision and did not do so. In their response to the motion to dismiss, the plaintiffs chose to rely entirely on a legal argument about the errors, whether the errors provision includes improper charges. Then, in their opposition to the motion to dismiss, they drop a footnote about how the bank, without clarifying what, that the bank raised matters outside the pleadings. So we go to the hearing on the motion to dismiss, and the district court judge asks opposing counsel this question directly. What do you contend is outside the pleadings? The judge asked this question after going into the dialogue about what the nature of their allegations are related to the notice provision, after asking what would be the implications if the court rejected the legal argument that this notice provision did not apply. After asking all of those questions, after making the admissions that plaintiffs did not comply, then the court asked about, do you still contend something is outside the pleadings? And plaintiffs' counsel said no. That issue about the scope of the pleadings was expressly addressed and answered in the negative by plaintiffs' counsel. And now the primary argument here on appeal is that it's outside the pleadings. So it was inviting the district court to commit an error then by making this admission that it was not outside the pleadings?
So at some point, the district court's opinion, if I recall, said you sort of chose CapFed to put the plaintiffs to put all your eggs in one basket, the legal basket. Did the court go ahead and rule and say, but because you haven't given notice, did it address the factual underlying issue, or did it rule solely based on the legal issue?
It ruled that the notice provision did apply. And if you look at the allegations, which were confirmed by the admission, I admit that it referenced the admission at the hearing, which confirmed what was in the pleadings, though. Again, plaintiffs chose to make the allegations of there's no compliance with the duty because we don't think these fees are errors. So the court then had to grapple with, well, if I had to take these admissions, would I really let this case continue after you've just confirmed what I thought was in your pleading, that you didn't comply and you were relying on a legal argument? And the court did note the admission by counsel, but that just confirms what they had already put in their pleading, and it addressed the fact that plaintiffs chose this legal argument as their sole defense. I just want to highlight, excuse me, I forgot we get 20 minutes. I just want to highlight the notice provision too, because opposing counsel opened by saying the clause applies to errors and improper charges such as fraud. The entire notice provision has one section that says you have to comply with this deadline for errors or improper charges. If you fail to do so, you're barred from bringing suit for those errors or improper charges. Then there's another section that follows a very similar format and relates to specific types of fraud, altered checks, forged endorsements. That's a specific section for a different type of issue. Goes through the same format. You also have to comply with the 30 days for these things, and you're barred from bringing suit if you don't comply. You cannot entirely delete the first section of the notice provision and read solely that it only applies to the forged endorsements and altered items that are discussed separately in the notice provision.
We should read it in context. in other
Correct.
words. Let me ask you on another different topic. Aren't we supposed to look at this fact that the judge was asked to dismiss and the other party wants to amend their petition? You know, normally our statute says leave to amend should be freely given. Aren't we looking at that with an abuse of discretion standard? Why did the judge feel like he had to dismiss this with prejudice here?
Because the plaintiffs chose to plead this issue in this way and rely on this legal argument, it was not an abuse of discretion to think that the plaintiffs could get around this same fatal flaw in an amended pleading. Plaintiffs were so confident in this legal argument that they chose not to seek the opportunity to amend. They chose not to file a brief addressing unconscionability or make any effort to try to comply with this notice provision. Instead, they made allegations that they had no duty to report purely because of a legal argument that was wrong. And so with the standard for pleading in good faith after that, how do you get around that? You can't. And so there was no abuse of discretion in denying that. And plaintiffs never offered a proposed amended pleading about how they were going to dance around this. And again, the contention that they didn't know because this was some sort of surprise is contradicted by the motion to dismiss briefing that put this directly at issue. And they chose to rely on a single legal argument that the court rejected. That's not an issue to be pled around in a second amended pleading.
So the court found it tacitly, it would be futile to amend?
And there's also, the judge didn't issue a finding about futility, but if I could potentially get in the judge's head based on how the arguments had progressed, I think that is a sound assumption. But also you can look at undue delay. The waiting until the eve of the hearing, or actually the last couple minutes of a hearing, to seek an amendment when this very issue had been put before the court and to plaintiff's counsel for months before, that is also undue delay and a proper reason to deny leave to amend.
Thank you.
So on this 12b6 standard, the Ziering case that the parties cited in their brief talk about how the court does not need to consider allegations contradicted by the description thereof and allegations contradicted by contracts attached to the pleadings. These contracts that we've been talking about were attached to the pleadings. The issue of whether plaintiffs provided notice was in the pleadings and then confirmed by counsel at oral argument. In order for the court to disagree with the district court and adopt plaintiff's argument, it would need to rewrite the contracts, which is improper and against the paramount public policy of the freedom to contract in Kansas. It would negate a notice provision where this court has enforced notice provisions in standardized contracts with insurance companies and consumers, hospitals and consumers. These types of notice provisions are part of Kansas's paramount public policy to encourage the freedom of contract.
What's the best Kansas case, or is there one that says this is not an unconscionable or an adhesion type contract?
In the, it's the Orkin case, that was a consumer case. It was affirmed by the Kansas Supreme Court without opinion. It just agreed with the Kansas Court of Appeals. But that case said there has been no finding by a Kansas court about a notice provision like that it was unconscionable. That was a contract that required a consumer to give written notice of issues with their services within a certain amount of time. That consumer provided oral notice, and eventually the court held that the provision was waived. That's not the situation we have here, but the Orkin case did say that those types of notice provisions are not unconscionable and would have been enforced but for the waiver.
It sounds strangely like dicta.
Well, that was an initial argument that they had to get to before they addressed the waiver, correct? But there are other Kansas cases.
But the ruling of the case was it had been waived.
Correct.
So all of that other is dicta.
Correct. But there are other Kansas cases that say notice provisions are enforceable. If you don't have any questions, that's all.
No, thank you. Mr. Seeley? Still have your 5 minutes.
Thank you, Your Honor, very much. I'd like to back up just a moment and see if I can better answer the questions that Your Honor, Judge Green, posed to me about certain pages of our brief. Specifically, the reference to Capital Federal being guilty of the same attempt to have it both ways, I think is explained perhaps inartfully in the sentences that follow, which span on to page 3 of the brief as well, which is that Cap Fed insists that these were improper fees for purposes of the notice provision, while at the same time arguing that its imposition of the fees was perfectly proper, making the fees proper. And I think we pointed that out because counsel for Cap Fed in their brief as at this argument have taken comment or taken the phrase improper as used in the amended petition out of context. Those references were in a generic sense and not in the context of the notice provision that we're now dealing with here. In other words, the term of the notice provision has to be construed, if it's ambiguous, in favor of the plaintiffs and against Capital Federal as the drafter. But improper is a more generic way of saying that there is something wrong with Capital Federal's deduction of these fees.
I think you've just given a classic reason why context is important.
Yes, Your Honor. We believe it's
Words carry meanings from their context.
yes, Your Honor. We believe it's very important. The context is very important in this case.
Is there any distinction? I mean, you've used the term a lot, improper fees, both in your briefing and today. Is there any distinction? I mean, when I think of a fee, it's like something that you're charged for service rendered by that bank or here.
Correct.
Is that any different than an improper charge?
I believe it is. A charge would be like a charge back or something like that, or something that was unexpectedly debited to the account. And again, I think you can draw a distinction based on the context that this is not what that clause as a whole was talking about. In fact, I think it was the Hartner case that we cited, Hartnett, I'm sorry, the Western District of Washington and 2 other federal cases involving notice provisions in bank account agreements that require notice of, quote, error, forgery, or other problem, unquote. Extremely broad language, probably even broader than the district court's reading of improper charges here.
Well, do we have a clue here in subsection G when the terms forged signatures, altered endorsements, unauthorized endorsements, and a merchant's failure to deliver a paid item are used as examples?
Yes, Your Honor.
Are they there for a reason?
We would suggest so.
And what is that reason?
That reason is to provide guidance to the parties to the contract about what sort of things require notice.
What they mean by improper
Yes, Your Honor.
in this context?
That's correct. In addition, Your Honor, counsel went into a lengthy explanation about the colloquy between the district court and my co-counsel, Mr. Khalil, about going beyond the pleadings. And in the transcript, I think it's very clear, certainly very vivid in my mind, having been in the courtroom, but the court's questions were about the defendants going beyond the pleadings. And I think in our brief, or maybe it was our reply brief, or our response to the motion to dismiss, we did say that we thought that the defendant was going beyond the pleadings. But when we went back and looked at it in preparation for the hearing on the motion to dismiss, we saw that they were really just saying that you hadn't pled it. They were not going beyond the pleadings. They were focused on the pleadings, the question of what was and wasn't pled. And as I indicated before, we had a general averment that all preconditions had been met. That's sufficient under Kansas law. That's not outside the pleadings. So But the problem here is that the court went beyond the pleadings. The court decided it needed to resolve this factual issue about whether notice had or had not been given. And unfortunately, it asked lawyers at that hearing, myself included, who were not prepared factually to answer that question.
Did they ask for leave to amend?
I'm sorry?
Did they ask for leave to amend?
Yes, we did ask for leave to amend.
And the response was,
No, it was
I
denied.
mean, rather eloquent, but was any reason given?
No. Your Honor, one other point I wanted to make, and this was also in regard to a question from Judge Green. Let's see. Oh, and that is, you had asked me if the issue of unconscionability was preserved. And I believe that in our briefing, we cited, in both briefs, actually, we cited to the portions of the transcript, which I believe it's volume 2, and I can't recall if that's just the transcript, if there's anything prior thereto, at pages 50 to 51, where Mr. Khalil did make the argument that the consequence of the court's conclusion that the notice provision was enforceable and operated to bar the claims was that language then operated unconscionably. And so we believe that it was clearly raised during the hearing and preserved for this appeal. The court has talked about the liberal standards for amendment. I don't think I need to belabor that. I do feel though that it's appropriate to note that in this case, because the district court went off track in terms of the legal standard that it was applying or the lens that it was viewing the case through, that was a legal error. And that the request for amendment in the context of that hearing, when we were suddenly faced with this development, was to ask for leave to amend so that we could address that legal error and mitigate the prejudice that was resulted from the court concluding that the claim should be dismissed with prejudice. The leave to amend was the rational, sound, equitable way for the court to address having raised and resolved this fact issue and having decided that the agreement must be read from the perspective of some hypothetical account holder as opposed to whether it could be reasonably susceptible of more than one interpretation. And so for all those reasons, we believe that the court should have granted leave to amend and that this court can and should reverse the court's decision, direct that the motion to dismiss be denied, and direct that the case proceed through discovery and resolution in the regular course. If there are no further questions, I will sit down.
Thank you.
Thank you, Your Honor.
We appreciate the arguments of both parties. Good arguments. We will take this case under advisement and get your opinion as soon as we can. We appreciate you coming here today. Thank you very much.